Hello, my name is Vedant Jain. I am a legal intern at LEXIS and Company. Today I am going to discuss a really important and crucial topic which every citizen of India should know about, which are rights of an arrested person. In case if anyone gets arrested for any offense or any crime which he or she may or may not have committed, there are certain rights which are provided to every individual of this country which he or she should know, and the state has to protect those rights and follow the principles which are given in our laws. Therefore, one of the basic tenets of our legal system is the benefit of the presumption of innocence until the accused is proven guilty in the court of law on the basis of the evidence which is presented in the court of the law. In a democratic society, even the rights of the accused are sacrosanct. Though accused of an offense, he or she does not become a non person. Rights of the accused include the rights of the accused at the time of the arrest, at the time of the search and seizure, and during the process of trial, and the like. The accused in India are afforded certain rights, the most basic of which are found in the Indian Constitution. The general theory or the general reason behind these rights is that the government or the state has enormous resources available to it for the prosecution of individuals, and individuals therefore are entitled to some protection from misuse of those powers by the government or the state. An accused has certain rights during the course of any investigation, inquiry, or trial of an offense with which he or she is charged, and he or she should be protected against arbitrary or illegal arrest. Police have a wide range of powers conferred to them to arrest any person which under cognizable offense without going to magistrate. So the court should be vigilant to see that this really powerful powers, are not abused for lightly used for personal benefits or for personal vendettas. No arrest can be made on mere suspicion or information. Even private person cannot follow and arrest a person on the statement of another person, however impeachable it is. Though the police has been given various powers for facilitating the making of arrests, the powers are subject to certain restraints or limitations. These restraints are primarily provided for the prosecution of the interest of the person to be arrested and also of the society at large. The imposition of the restraint can be considered to an extent as the recognition of the rights of the arrested or the accused person. There are, however, some other provisions which have rather more expressly and directly created important rights in favor of the arrested person. In the leading case of Kishore Kumar Ravinder Dev versus State of Rajasthan, it was said that the law of India, that is constitutional, evidentiary, and the procedural, have made elaborate provisions for safeguarding the right of accused with a view to protect his his or her dignity as a human being, and giving him or her benefit of a just, fair, and impartial trial. However, in another leading case of Menka Gandhi versus Union of India, the Supreme Court interpreted that the procedure adopted by the state must therefore be just, fair, and reasonable. So here are the rights of the persons which are accorded to every individual rights of an arrested person which are accorded to every individual in India. First, right to silence. The right to silence is a principle of common law, and it means that normally courts or tribunals of facts should not be invited or encouraged to conclude by parties or prosecutors that a suspect or an accused is guilty merely because he or she has refused to respond to questions put to him by the police or by the court. The Justice Malimat Committee writes about Justice Manual Committee writes about the origin of the right to remain silent, that it was essentially the right to refuse to answer and incriminate oneself in absence of a proper charge. Not initially, the right to refuse to reply to a proper charge. The Justice Malimat Committee's assumption is that the right to silence is only needed in tyrannical societies where anyone can be arbitrarily charged. It assumes that whenever a charge is proper, there is no need for prosecution of the accused. In this backdrop and in this background, it becomes necessary to examine the right to remain silent and its companion right against self-incrimination. These are the two aspects of fair trial and therefore cannot be made a subject matter of legislation. The right to fair trial is the basic premise of all procedural laws. The very prescription of procedure and the evolution of procedural law have to be understood in the historical context of the anxiety to substitute rule of man by rule of law. In any law, any statement or confession made to a police officer is not admissible. Right to silence is only concerned about confession. Breaking of silence by the accused can be before a magistrate but should be voluntarily and without any duress or inducement. To ensure the truthfulness and reliability of the facts he stated, the magistrate is required, he or she stated, the magistrate is required to take several precautions. Right to silence and right against self-incrimination have been watered down quite considerably by the interpretation than by the legislation. The defendant, if he or she so desires, can be a witness in his trial. His confession outside the court, either to a police officer or to a magistrate, is admissible. He is encouraged to betray his colleagues in crime on promise of pardon. He is expected to explain every adverse circumstances to the court at the conclusion of evidence, with the court having jurisdiction to draw adverse inference while appreciating the evidence against him. The Constitution of India guarantees every person right against self-incrimination under Article 20, Clause 3, which states that no person accused of any offence shall be compelled to be a witness against himself. This is the principle of self-incrimination. It is well established that the right to remain silent has been granted to the accused by virtue of the pronouncement in the case of Nandini Satpathy versus P.L. Dani. It is a famous case where it was held that no one can forcibly extract statements from the accused who has the right to keep silent during the course of interrogation or investigation. By the administration of this test, forcible intrusions into one's mind is being restored to and therefore nullifying the validity and legitimacy of right to silence. In 2010, the Supreme Court made narco analysis, brain mapping and lie detector test as a violation of Article 20 Clause 3, and this test are not valid in the course of investigation conducted by the police or the state officials. Second right is right to know the grounds of arrest. Firstly, according to Section 50 Clause 1 of CRPC 1908, it stated every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offence for which he or she is arrested or other ground for such arrest. Secondly, when a subordinate officer is deputed by a senior police officer to arrest a person under Section 55 of CRPC, such subordinate officer shall, before making the arrest, notify to the person to be arrested the substance of the written order given by the senior police officer specifying the offence or the other cause for which the arrest is to be made. Non-compliance with this provision will render the arrest illegal. Third, in case of arrest to be made under a warrant, Section 75 CRPC provides that police officer or other person executing a warrant of arrest shall notify the substance thereof to the person to be arrested and if so required shall show him the arrest warrant. If the substance of the warrant is not notified, the arrest would be unlawful. The Indian Constitution has also conferred on this right the status of the fundamental right. Under Article 22, Clause 2 of the Indian Constitution, it provides that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor shall he be denied of the right to consult or to be detained or to be defended by a legal practitioner of his choice.